campaign finance laws in Citizens United and voting rights protections away in Shelby County. The tool of choice of these activists is a supposedly neutral judicial philosophy of originalism and textualism, which gives judges the ability to substitute their own judgment for the elected branches and to strike down and restrict laws that are disfavored by powerful special interests. President Trump has been open in acknowledging that he wants a nominee on the court to strike down that ACA. You have said you have not made any agreements or statements to the contrary, but I will tell you, it is a cloud over your nomination because he has over and over again. He's nominated other such advocates of originalism and textualism to carry out his political purposes. I'm afraid of the impact of that repeal on people like Jared. So we've been told that you're following the Ginsburg rule, no hints, no previews, no forecast. In fact, during her confirmation hearing, Justice Ginsburg did answer substantive legal questions about matters that might come before the court, such as the right to choose. Yesterday, you had one notable and selective departure from your interpretation of the Ginsburg rule. When it comes to California versus Texas, the Republican challenge to the Affordable Care Act, you repeatedly claim that the deciding question in the case is severability, not the individual mandate. That's a legal opinion. But the court will only reach the severability question if it first finds that eliminating the penalty for the individual mandate rendered the individual mandate unconstitutional. Isn't that right?
Senator, what I meant by that is that even if the mandate is unconstitutional, severability would, if it is severable, then the statute would stand. And so if the mandate is constitutional, then yes, the law would stand. But I said that the emphasis, and I've gotten a lot of questions about severability for this reason, and much of the commentary in the legal news about this is focused on severability because it means that whatever the holding is on the mandate, the severability question is the one that would be determinative, even if the mandate were held unconstitutional. So it's a descriptive. I didn't say how I would rule on severability, and I didn't say whether I would interpret the zeroed out provision to be a penalty rather than a tax.
But you see, that second part, penalty tax, you've already addressed that, haven't you?
No, I haven't. The writing that I've done before that I assume you're referring to addressed a different provision that wasn't zeroed out. This is now an amended provision, so it's a different provision before the court.
But you're on record for criticizing Chief Justice Roberts' opinion that the individual mandate is constitutional. Haven't you?
I am on record saying that I thought that the majority opinion was a less plausible interpretation of the statute than that of the dissent. Again, that was an academic writing, number one. Number two, it was on different issues than those are presented in California versus Texas. And number three, I think you're suggesting that I have some hostility to the ACA, which I assure you that I don't. And I think, Senator Durbin, there's actually something you and I agree on here. Judicial activism is bad from either side. And no matter what somebody's policy preferences are about the ACA, I completely agree with you. They shouldn't be trying to undermine the policy that Congress enacted. So you and I agree on that, and I embrace that view of a judge's role wholeheartedly.
Thanks, Judge Barrett.
We'll do Senator Lee, White House, and Cruz, and break for lunch.
Thank you, Mr. Chairman. Mr. Chairman, I'd like to submit to the record a letter from the American Legislative Exchange Council.
Without objection.
Judge Barrett, I want to talk about religious freedom for a moment. As I mentioned the other day, I think you and I share something in common on this, an enthusiasm for religious freedom. As I mentioned the other day, I'm a member of the Church of Jesus Christ of Latter-day Saints. We have been no strangers to religious persecution, even in this country, unfortunately. On October 27th, 1838, the governor of Missouri ordered us exterminated. It wasn't nice, but, I assume he had his reasons. He believed we were heretics, and I'm sure we are heretics in the eyes of many, but we try to be really nice heretics. And it wasn't until the late 70s that the governor of Missouri actually lifted that ban. I'm sure Josh Hawley, as Attorney General, would have lifted it for us had it not been lifted by then. Religious liberty has always been interesting to me for that reason, and also just as a lawyer. My late father, who was also a lawyer, worked on and advised Congress regarding the Religious Freedom Restoration Act. And my longtime professional mentor and former boss, Gene Scher, was someone who I worked with in establishing a first-of-its-kind religious institutions practice group a couple of decades ago. Catholics, like members of my faith, have also been subjected to religious persecution from time to time. And in many cases were directly targeted through so-called Blaine amendments, provisions worked into a number of state constitutions, really for, in many cases, blatantly anti-Catholic purposes. These Blaine amendments had, of course, as their purpose the restricting of public funds going to certain religious institutions, including schools. Thankfully, earlier this year, the Supreme Court in Espinoza versus Montana Department of Revenue struck another blow against Blaine amendments by reinforcing their earlier decision in the Trinity Lutheran case. Would you discuss briefly with us the Supreme Court's recent jurisprudence on this issue regarding Blaine amendments and how they intersect with religious freedom?
Sure. So the Supreme Court's recent decisions get at the principle that while, we have to be careful about the Establishment Clause, right? So there's a line of cases saying, a state or federal government clearly can't establish a church. And so we have a line of cases about what that means. But at the same time, Espinoza being an example, the court has been very clear that religious institutions can't be discriminated against or excluded from public programs simply because they are religious.
Now, during your time on the Seventh Circuit, you've been able to handle some cases involving religious freedom issues. For example, you joined a majority opinion in the Gruscott case, upholding the freedom of a Jewish religious school and its authority, its own discretion to hire teachers at its school. That ruling was challenged before the U.S. Supreme Court, but the Supreme Court denied certiorari in that case. But nonetheless, a 7-2 majority of the Supreme Court in the Our Lady of Guadalupe case ended up essentially adopting a position similar to that which you joined in the case I just mentioned, in the Our Lady of Guadalupe case. Can you talk to us just a little bit about that opinion and about the Seventh Circuit opinion and its application of the ministerial exemption?
Sure. So the ministerial exemption, as you say, the court had described it in Hosanna Tabor. The ministerial exception gives religious institutions discretion to hire, and in the case of a school, teachers. It's called who are ministers. And what this gets at, or what this requires courts to do, is to decide who is a minister. And on the one hand, there may be some which you could plainly, what might be more obvious questions, like, someone who teaches religion teachers. So what the court has said is, those would follow more in the heartland. It gets a little bit more difficult if you have a religious school, like the Jewish school in Gruscott, or the Catholic school in Our Lady of Guadalupe, who has a teacher that's like, say, for example, teaching math. And then the courts have to come up with a test to decide whether such a person is a minister or not. And what Gruscott and Our Lady of Guadalupe said is it's a multi-factor test where no one factor is determinative. So it can't be determinative just that the teacher teaches math rather than religion. For example, in Gruscott, the teacher spent time teaching Jewish prayers and saying Jewish prayers with the class. And the school considered it part of the teacher's duty to form the students, to teach them about Jewish prayers and to form them in that tradition. So even though she spent other time in the curriculum teaching other matters, it viewed that as part of her job, and the school viewed her as a minister. And so Our Lady of Guadalupe gives a lot of deference to the school's characterization of whether someone is a minister or not to encourage discrimination, of course, but simply to protect religious freedom. So at a Catholic school, the teacher may teach math, but also prays with the students in the morning, attends mass with them during the week, and is considered by the school, say in Our Lady of Guadalupe, to be someone who is also forming children in the faith. So it's really about what the scope of that ministerial exception is and how you identify whether someone is a minister.
Thank you. That's helpful. When you came in front of this committee in 2017, we're talking about just over 3 years ago, for your confirmation to the U.S. Court of Appeals for the Seventh Circuit, you said, quote, "If there is ever a conflict between a judge's personal conviction and that judge's duty under the rule of law, it is never permissible for that judge to follow their personal convictions in the decision of the case rather than what the law requires." You still stand by that statement?
I do.
I've got some colleagues on the other side of the aisle who seem to want to focus on statements made in your personal capacity and in your capacity as a private citizen and a member of your faith, as opposed to addressing actual cases dealing with abortion. I have a hunch that this is because your record on the Seventh Circuit actually shows that you're able to set aside your personal convictions, because that's what you've done when they've conflicted with your duty under the rule of law. In Price versus Chicago, for example, I assume you remember that case. It's a case in which you joined a Seventh Circuit panel opinion affirming the legality of a Chicago buffer zone law, which places limits on pro-life activists as they're demonstrating, exercising their First Amendment rights outside of abortion clinics. I assume that was the case because there was binding Supreme Court precedent on the abortion buffer zone issue. Is that right? Or do you want to tell me a little bit about your reasoning in that case?
So the panel held that the issue was squarely controlled by the Supreme Court's decision in Hill versus Colorado.
So there was binding precedent on point, and so you followed that precedent, and you did so as a jurist, rather than following whatever personal predilection might have otherwise guided you or any other member of that panel. In Planned Parenthood of Indiana and Kentucky versus Commissioner of Indiana State Department of Health, you joined a dissent written by Judge Frank Easterbrook of the Seventh Circuit. And the Supreme Court later agreed with you in a 7-2 decision with respect to the Indiana law requiring fetal remains to be buried or cremated following an abortion. A position that garners a 7-vote majority on the Supreme Court these days, at least a 7-2 decision that includes Justice Breyer and Justice Kagan. Does not seem very radical to me. Do you disagree? Am I missing something about that?
The Supreme Court summarily reversed, which means without argument and briefing, the panel's holding in that case that the fetal remains, the disposition of fetal remains portion of that statute wasn't rational.
I'll note for the record here, I don't think I've ever heard anyone characterize as a radical act of conservative activism a 7-2 decision joined by Justice Kagan and Justice Breyer. Judge Barrett, in addition to being able to set aside your personal convictions when deciding a case, you've also demonstrated the ability to expertly determine what the law requires. This stems, I believe, from a fundamental and I believe correct view that a judge needs to start from the premise that the law provides an answer. The fact that legal disputes can be difficult and reasonable minds might disagree as to them doesn't excuse the judge in believing that there is a right answer. And you seem to follow with that, and it shows up in your work in a way that reflects very well on you. The Congressional Research Service conducted a review of your cases from the U.S. Court of Appeals for the Seventh Circuit and determined that your decisions, and this is a quote, evince case-by-case consideration of the relevant law and facts without any clear overarching trend toward either expanding or narrowing Fourth Amendment protections, close quote. Now, this is exactly what I would expect from a textualist originalist on an issue that, like the Fourth Amendment, can actually be politically charged. But with the textualist originalist, this is exactly what you'd expect to see, somebody who doesn't appear to be a partisan one way or another and comes down on both sides, on the government side and on the non-government side. This would also account for a variety of outcomes in your cases, because you're not aiming for an overarching trend in outcomes. Your analysis seems sometimes to come out in favor of a defendant, sometimes in favor of the government. I find your dissents and your concurring opinions in panel decisions that demonstrate this commitment to following the law as it's written, rather than on the basis of some external objective. Can you tell us why you felt the need to dissent in the case of Schmidt versus Foster?
Yes. So Schmidt versus Foster involved a state court case. It came up through the Wisconsin courts. And in the case, there was a question of whether the defendant could raise a defense under Wisconsin law called adequate provocation for having murdered his wife. The case wound its way through the Wisconsin courts, and the defendant argued that an ex parte examination of the judge at which his counsel was present but not permitted to speak did not violate the Sixth Amendment, because in that case, the defendant, they didn't want to preview his case for the prosecutor, and so he didn't want the prosecutor in the room. So the judge said, well, I will allow that, but only if your attorney doesn't speak, because, if we're not going to preview your case for the prosecution and not permit the prosecutor to be here, that was how he's going to do it. So then the judge proceeded to ask the defendant questions to decide whether he could make an adequate provocation defense, and concluded that he could not. In that case, the Wisconsin courts held that this proceeding did not violate the defendant's right to counsel, this, telling his counsel that he couldn't speak. It came to my court under 2254, which is the state habeas statute permitting collateral review of state convictions. But EDPA requires very heavy deference to state courts. You can only disturb a state court holding, for example, on a matter of law, determination on a matter of law, if no reasonable jurist could reach that conclusion, or it has to be in conflict with clearly established Supreme Court law. And in that case, I made clear that it wasn't up to us to decide whether we thought as an original matter, just if the case had just come up before us, whether that violated the Sixth Amendment, because as the panel majority, which then became a dissent when the case went en banc, said this was an unprecedented kind of hearing, which, if it was unprecedented, meant that there was no clearly established Supreme Court law on point. So the decision in that case was driven by federalism and by the statutory instruction that federal courts give deference to state courts.
Thank you. In another case, United States versus Wilson, I believe that was a case in which you agreed with the majority in concluding that the officers acted with reasonable suspicion based on the circumstances of the case and the detention there involving a flight by the individual from the scene. But you wrote separately. Tell us why you wrote separately in that case.
So that case, if I have the case correctly, I've been almost 600 cases, but I think I know the case that you're talking about. I think that was a case where police had a tip about some criminal activity, and there were a group of men in a park. The police approached the park, and then they went up to talk to one of the men at the park because they noticed a bulge in his pocket. He was wearing gym shorts or some sort of athletic shorts that showed a bulge. And the police approached the man, and he fled. And under Supreme Court case law, the determinative question for a seizure is, whether the person fled and then was detained, then seized by the police. The other way that could have been justified is if, as a matter of a Terry stop is the case, the police had reasonable suspicion to approach him just because they saw the bulge in his pocket. And I wrote separately because I thought that the policeman's basis for stopping him, if this really had just been a Terry stop based on reasonable suspicion, was questionable because they had an anonymous tip. The people in the park didn't match the description of the description given in the anonymous tip. All they saw was a bulge in the pocket. So if he had not fled, I thought the case should have just talked about the flight, because if he had not fled, I was pretty dubious that would have been a justified stop.
I admire your decision to write separately in that case. I think that shows real courage and moral and judicial leadership to speak out and write separately when the occasion requires it. And you did so here with nothing to gain from it. You did so because it was important to point that out under the law, and I respect that a lot. In the couple minutes we've got left, I wanted to ask you more broadly about something I've noticed in reviewing letters and other materials we've received in response to your nomination. I've noticed that there's a common theme among your law clerks and your students. They feel like you see them as individuals, and they feel mentored and taught by you. Tell us a little bit about that. I'd love to hear, for example, how you go about deciding who to hire as your law clerks, and how you mentor them as they go through their year studying with you.
So over my teaching career, I've taught roughly 2,000 students. And now I have, as a judge, 4 law clerks per year. And then I also continue to teach at least a seminar in which I have like 15 or so students usually. And, what I'm looking for in a law clerk, of course, is, excellent legal ability, because I need the help, to do the legal research and all of that sort of thing. So I want someone who has excellent legal ability. I want someone who has integrity. I want someone who isn't afraid to push back and express his or her own opinions, but at the same time realizes that, I am the boss, and if I disagree, then they're going to have to go along ultimately. But I also want clerks who are, and this is part of the integrity, who have character. Our chambers is small. If someone had, say, sharp elbows, in a chambers that only has 6 people, my assistant, the 4 law clerks, and me, or that showed disrespect or arrogance, that would make for a pretty miserable year for everyone. And I've not been disappointed. Every one of my law clerks has fit that bill. And so I view it as my duty with my law clerks, much like with my students, to encourage them to enter the profession as full people who hopefully have gained some knowledge of the law in their time with me, and also seeing how they can, live a life where people can disagree without being disagreeable.
Thank you, Judge Barrett. I see my time's expired. Thank you, Mr. Chairman.
Senator Whitehouse.
Thank you, Chairman. Judge Barrett.
Senator?
First, if I may, Chairman, let me ask unanimous consent that an essay I wrote for the Harvard Journal on Legislation called Dark Money and U.S. Courts be admitted to the record.
Without objection.
That a report that Senate Democrats prepared called Captured Courts be admitted to the record. And that an article by Christopher Leonard in the New York Times called Charles Koch's Big Bet on Barrett, describing activating his political network to support Judge Barrett's nomination, also be entered to the record.
Without objection.
Thank you. Judge Barrett, on the Seventh Circuit, you are subject to a code of ethics, are you not?
I am.
And I presume you are okay with that?
Of course.
In fact, I would submit you probably think that's a good thing.
Yes.
And indeed, it is true of all the circuit courts that they're subject to pretty much the same code of ethics, correct?
Yes.
It gets different at the Supreme Court. Supreme Court is not subject to a code of ethics, is it?
The canons of judicial conduct that apply to lower court judges do not apply to the Supreme Court, although I do believe it's the practice of the Supreme Court to follow them.
Yeah, they do not apply, we agree. And indeed, going to the Supreme Court can interrupt an ethics investigation, as we saw with Justice Kavanaugh, who had an ongoing ethics investigation in his circuit that was interrupted by his elevation to the Supreme Court without having concluded. Let me first ask you, there's no such thing with you, correct? We have no Seventh Circuit ethics investigation going on that would be interrupted by your elevation to the Supreme Court.
I'm not aware of any ethics.
I suspect you would be, so good. We can put that behind us. With respect to reporting of gifts, of travel, of hospitality, of what the Constitutional might call emoluments, all of the circuits have a pretty solid rule about reporting those, and you comply with that rule on the Seventh Circuit, do you not?
I do. It might even be by statute that we have to do that, but I do.
Yes. And the rule, I don't know how familiar you are with this, so I'll offer this as a proposition. The rule that you follow and the way in which circuit judges follow it aligns quite well with the reporting requirements that in the executive branch members of the cabinet have to do when they get gifts, travel, hospitality, and other emoluments. And it aligns quite well with the reporting that members of Congress have to do when we get gifts of travel or hospitality or other such emoluments. The discrepancy here is with the Supreme Court, which has a much lower standard of transparency and disclosure about those very same things. So it's a bit of a mystery when I see the situation that when you go up to the court, you will be not subject to the code of ethics that you're subject to now or any other, and you will have lower reporting requirements than you do now or that any of us do. And I flag that for you because I think it's anomalous that the highest court should have the lowest standards. And I don't know if you want to say something about that. At a minimum, I hope you'll keep an open mind about trying to fix that when you're on the court. If you have a defense of why the highest court should have a lowest standard, have at it now.
I didn't know. I know that the justices file financial disclosure reports. I've never looked at one. I didn't know that they were different or that it was a lower standard from the ones that the rest of us
Okay,
file.
well, take a look at that when you get up there. This is a matter I think that the court handles administratively.
I've never interrupted anybody, but can I just ask one question?
Of course.
Now that you know that, how do you feel about it?
That the
Does that stop my time while you're answering the chairman's question?
Time, but I think it's a good question. Now that you know, how do you feel about it?
I guess, as I just said to Senator Whitehouse, I'm surprised because I did think it was by a statute that applied to everyone. So I'm surprised. I've always complied with filling out my financial disclosure reports. And as I'm sure it may have been for you all, it's a little uncomfortable the first time to make your finances available. Anybody can request it. But I've always complied.
For the record, it's a question of interpretation and practice. And Senator Graham and I have actually had public conversations about trying to remedy this with a legislative fix. So you've got that potentially coming your way. So I flagged that for you. The second thing, another topic I'd like to raise with you is you've repeatedly mentioned during this hearing the phrase about litigation winding its way up through the courts and ultimately to the Supreme Court. And you've described that process of winding its way as an important restraint on judicial activism. that you got to wait till a case gets to you in the ordinary course, correct?
Correct.
That's a fair description of where you've been?
Correct.
Yeah, and the ordinarily, I don't know if you've ever done a case, but ordinarily when you do a case, it begins with a person, right?
Correct.
And that person feels an injury,
Yes.
and then that person goes to a lawyer,
Yes.
and then that lawyer goes on their behalf to court
And files a complaint.
and files a complaint, and then in court they try to win and vindicate their injury. That's kind of the basic standard way in which this works.
Yes.
So it gets a little weird sometimes, and that's a circumstance I'd like to bring up to you because it touches on some of the stuff that I addressed yesterday. One case, it's not even a case. Janus,
Yes.
okay? Let's describe this as the Janus saga because it's more than really one case. And it's really about a completely different case called Abood. You're familiar with the Abood decision.
Yes.
So the Abood decision was precedent for what, 40 years?
I can't remember when Abood was decided, but it was precedent before Janus.
Yeah, and roughly 40 years, I'll tell you. And had repeatedly been reaffirmed.
It was a longstanding precedent.
Yeah, on which there was considerable reliance.
Let's see. So Janus did overrule that precedent, and so Janus did go through the application of the stare decisis factors in deciding whether to overrule it,
Right.
whether that
And there
conclusion
was in
right or
fact
wrong.
reliance in the 40 years that it had been the law of the land on the question of the union question that it had resolved.
Well, I don't want to second guess or criticize or praise the majority in Janus's
I'm not asking you to. I'm
calculation.
asking you, as a matter of fact, had 20 plus states relied on it?
Well, Senator, I think reliance and the degree of reliance on Abood is a legal question.
We'll just leave that then. So the Janus saga begins actually with a case called Knox, in which Justice Alito took a shot at Abood. He criticized it as substantially impinging upon First Amendment rights of union members. Just for people who are watching, the Abood case was about the right of a labor union to get compensated, not dues, but just compensation from non-members when in their representation of their members, they get added benefits for the people who are not members. So not the most exciting part of the law, but settled this question of when labor unions could get compensated for work they do for non-members. But Justice Alito did not like it. He took a shot at it in Knox versus SEIU, and the concurrence in that case said, whoa, wait a minute. Quote, the majority's choice to reach an issue not presented by the parties, briefed or argued, disregards our rules. But Justice Alito didn't like something about Abood, and so he took that shot. Then we went on to a later decision called Harris v. Quinn. Alito took another shot at Abood in that case, describing Abood as having analysis that is questionable. He undertook an extended critique of the decision, describing it as having questionable foundations. Justice Kagan spotted that, and in her dissent, she said, today's majority cannot resist taking potshots at Abood, and described its critique of Abood's foundations as gratuitous dicta. But the message went out from Judge Alito that he wanted to do something about Abood. There was something about Abood that he did not like. And with that, we went to, that's the prequel. Then we went to the two cases that followed. The first one was Friedrichs, which was supposed to be the case that got rid of Abood. And it had an interesting travel because the lawyer in the case was one of these groups from Janus. It was the Center for Individual Rights right here, who was counsel. In Janus, the National Right to Work Legal Defense Foundation was counsel. So they switched, right? In Friedrichs, Center for Individual Rights was counsel, National Right to Work was an amicus. When it went on to Janus, they switched. National Right to Work Defense Foundation was counsel, and Center for Individual Rights was an amicus. And from everything that I see, it looks like they actually went out and found the plaintiff. So back to our earlier discussion, it wasn't the injured person that went and hired a lawyer. It was the legal group that went and found a plaintiff. And then they went to court, which everybody does. But it got interesting there because there the lawyers asked to lose. I don't know if you've ever been in a case in which the lawyers asked to lose before. I never have been. I've never litigated against anybody who asked to lose. Have you ever been in a case in which a party asked to lose?
No, I don't think I've ever experienced that.
Yeah, I can imagine not. So these groups with all this money behind them from Donors Trust and Bradley Foundation and all come into court and they say, please dismiss my case in the district court. Then they go up to the Ninth Circuit and they specifically ask the Ninth Circuit to get rid of their case, to uphold the decision dismissing their case, quote, as quickly as practicable and without argument. Have you ever seen a case in your circuit where somebody came in and said, I'd like to lose, and I'd like to lose as quickly as practicable, and I'd like to lose without making an argument on behalf of my client?
But Abood was controlling law at that point, right?
My question was, have you ever seen that happen in your circuit?
I have not seen that happen in my circuit.
Yeah. Okay. So then the case went on to decision, and as predicted or signaled by Justice Alito, it looked like it was going to be a 5-4 decision knocking out Abood after 40 years. Sadly and unfortunately, Justice Scalia died before that decision could be rendered, so it actually turned out to be a 4-4 decision. And as you know, a 4-4 decision, the tie goes to the decision below, and the Ninth Circuit prevailed, and so that was it for Friedrichs. But it didn't take long for this same group. So this is back to my Janus exhibit. These are all the commonly funded amici and lawyers who showed up in Janus. 11 of them had showed up in Friedrichs. So Janus was a reunion of the team. Everybody piling back in together to get what they... And there was no big rush this time, because this time they had to wait for the vacancy on the court to be filled. They didn't want a 4-4 decision. They had to wait for Justice Gorsuch. So there wasn't the same rush. The case came through more ordinary travel, and then, boom, in they went to argue it, and down came the decision. And I ask you to think that through, because I've done some appellate argument, and I've done some trial work, and I have run an awful lot of litigation. And one of the things that has been a constant for me has been the belief that even if I was kind of taking a long shot case, I'd get a fair hearing, I'd get a fair decision, and I had a shot. I've got a feeling that the lawyers going into the United States Supreme Court in that Janus case, looking at this array of commonly funded anti-union front groups assembled against them as amici, having seen what Friedrichs portended, having been signaled by Alito in those earlier cases that they wanted to get rid of Abood, that they was on the hunt for Abood. That's a feeling that no lawyer should have in America. And all I want to do is leave with you the thought that when you're on the court, I hope you will conduct yourself and see in whatever way you can that the court conducts itself in such a way that no lawyer goes into an argument in the United States Supreme Court feeling that the case is set against them and there's nothing to be done other than go in and take your medicine.
Senator Whitehouse, I will approach every case with an open mind.
So I have a little bit of time left, so I'm going to get onto a third. By the way, I'm not the only one who sees this as a saga. The dissent in Janus said, here ends the, quote, 6-year campaign to undo Abood by the majority of 5. Pretty safe to say that you don't think courts should be campaigning to reach decisions.
Without commenting on
Correct.
Janice or what happened there,
Correct.
yes, I think that judges shouldn't have campaigns.
Or projects.
I think judges should not have pet projects and they should not have campaigns. They should decide cases.
Thank you. So let's talk about, because we've had all these, I think, odiferous amici fluttering around the court without disclosing who's really behind them, let's talk about amici for a minute. First of all, on the Seventh Circuit, do you have ex parte meetings with litigants?
No.
Because why?
Well,
Because
there would
it's wrong?
yeah, sure. I mean, there are constraints against doing so.
And how about with amici? If you have a case in which there is an amicus in a case that is before you, would you meet privately with the amici while the case in which they've written a brief is pending?
You mean meet privately, allow the amici to have access to the judges
Yes.
privately
Yes.
to try to make the case? I would not do that.
No. And why would you not do that?
That would be inappropriate.
Yep. And in fact, is it possible that you could not even know who was really behind the amicus if they haven't told you?
You mean how the amicus was funded?
Correct.
To my knowledge, I'm thinking through what the disclosures are in the fronts of briefs. I mean, to my knowledge, that information is not part of what groups disclose.
Correct.
When they file amicus briefs.
Correct. There's actually a bit of a tradition that has developed that amici, in their disclosure, only describe who paid for the actual physical preparation and filing of the brief. So if you had a big interest, let's say, that went and gave a group $1 million, maybe even stood up a pop-up group out of no place and said, here's $1 million, I want you to go out and do great things. Oh, and by the way, we'd sure appreciate it if you filed an amicus brief in this matter, just don't mention us. And we'd love to give you some advice about what you should say in the amicus brief, and it would be nice if you'd let us read it before you file it so we can make sure we don't need to give you any more advice. That doesn't meet the standard of 37.6. The court and the parties would never know. And in fact, this happened in the Oracle case, in Oracle versus Google. Turns out that Oracle had given up to $99,000, according to their disclosure, to something called the Internet Accountability Project, which filed a brief and didn't disclose that Oracle, a party in the case, had given it $99,000. And Internet Accountability Project was basically a pop-up. Somebody established it, it took the money, it wrote the brief. There's a group that has more cred that's been around longer called the American Conservative Union, which was given up to $500,000 by Oracle and filed a brief in the Oracle case and didn't disclose that it had been given that kind of money by Oracle. Isn't that the kind of stuff that parties ought to know, that the public ought to know, and that the court ought to know?
I didn't know that until you just shared that information with me.
Well, think about it, because I think it's something that the public and the parties and the court ought to know. Because if what you have is amicus groups that are coming in flying false flags, not revealing whose interests they're really there to support, and potentially teeing up arguments and ideas that will benefit the secret funders, that will maybe tee up for a case they know is coming but isn't this case, but if they can tilt the law a little bit in it, it can have an effect later on. Other parties should know that. So I urge you to consider that, and I'm 13 seconds out, so I'll leave it with that. Please think about these things. There is something that is not right about the way this is happening, and I urge you, and I urge anybody from the court who is listening, to try to sincerely try to clean this mess up, because it is not good for the court. Thank you.
Thank you, Senator Whitehouse.
Senator Cruz.
Thank you, Mr. Chairman. Let me say, first of all, the last 3 days of hearings have revealed very good news. They have revealed the news that Judge Barrett is going to be confirmed by this committee and by the full Senate. With 2 full days of questioning, we've seen that our Democratic colleagues have very few questions actually to raise about Judge Barrett's qualifications. Very little of the time we've spent in here has concerned her record as a judge, her 20 years as a respected scholar. Instead, much of this hearing has focused on political attacks directed at President Trump. I recognize our Democratic colleagues are not going to be voting for President Trump in November. That's certainly their prerogative. But they've largely abandoned even trying to make the case that Judge Barrett is anything other than exceptionally well qualified to serve as a justice. It is striking that as we sit here right now in this committee room, there are only 2 Democratic senators in the room. If you look at the dais, there's chair after chair after chair that is empty. The Democratic senators are no longer even attending. I assume they'll show up for their time. But it is indicative of what they're tacitly admitting, which is that they don't have substantive criticism.
Mr. Chairman, may I make a point of personal privilege?
Of course.
We're in the midst of a COVID-19 crisis, a pandemic, and some members are in their offices following this on television, and to suggest their absence here means they're not following or participating is incorrect.
I would note the senator from Illinois, in his personal privilege, somehow omitted the fact that all but 2 of the Democrats were physically here yesterday, and after the questioning, they made the decision not to be here. That's fine. You're welcome to make that decision, but it's indicative when it comes to the time of the questioning that this side of the aisle does not have arguments against Judge Barrett that have any chance of prevailing. I do want to address a couple of the individual points that have been made. So many of the Democratic senators have talked about Obamacare at great length. At times I have been confused, and I thought we were on the Health Committee instead of the Judiciary Committee because it has been such a central talking point for every Democrat that if President Trump is reelected, they assert everyone with pre-existing conditions is going to be denied health care and people will be dying in the streets. And I get that's their reelection message. It's not actually connected to reality. It's not actually true. Every member of the Senate agrees we're going to protect pre-existing conditions. And I would note that not a one of the Democratic senators who raised that point have addressed the very real and catastrophic failures under Obamacare. Obamacare has doubled the profits of the big health insurance companies, doubled them. Obamacare has been great corporate welfare for giant health insurance companies. At the same time, according to the Kaiser Foundation, average families' premiums have risen $7,967 per year on average. That is catastrophic that millions of Americans can't afford health care. It is a catastrophic failure of Obamacare. And none of that has anything to do with Judge Barrett's nomination to the Supreme Court. That is a very good argument for members of the Senate to be having. And yes, we should be protecting pre-existing conditions and expanding competition, expanding options, and lowering premiums. This body will continue to debate that, but Judge Barrett will not be the decision maker on what the appropriate approach to health care is as a policy matter. A second point I want to address, Senator Durbin had an exchange with Judge Barrett about the right to vote and also about the Second Amendment. Now, as a policy matter, many Senate Democrats, number one, want to see the Second Amendment abridged to the maximum extent possible. And number two, many Senate Democrats have decided as a policy matter that they would like to see as many felons as possible able to vote. That it is, one would presume, they have made a determination it's in their political interest to have more felons, more convicted murderers, more convicted rapists, more people convicted of domestic abuse voting, that they've made an assessment that that helps their prospects on election day. They're entitled to make that policy determination, and different states have made different determinations about in what circumstances felons should be allowed to vote, in what circumstances felons should not be allowed to vote. I, for one, am a bit puzzled. I'm not sure our democracy is better by changing the law to allow murderers to vote. I'm not sure the operation of the republic would be better if Charles Manson had a greater voice in the electoral system. And I would note one of our colleagues, Senator Sanders from Vermont, in the course of the Democratic presidential primaries, argued not just felons who are out of jail, he argued that felons in jail, literally Charles Manson, serving a life sentence, or I think multiple life sentences for murder, should be able to vote. It's a policy matter. I think that's pretty out there. But the interesting thing is, Judge Barrett wasn't called upon to make a determination whether as a policy matter every felon should vote or no felon should vote or somewhere in between. Rather, she was doing a very different thing, which is applying the law. And Judge Barrett, did I hear you correctly that when you were describing your dissent in the counter case, that one of the reasons you said that there was a difference in the law as it concerned voting versus the Second Amendment is because the 14th Amendment, the text of the 14th Amendment explicitly contemplates legislatures making restrictions on voting based on whether you've committed a crime? Is that right?
That's right.
And I actually have the text of the amendment because Senator Durbin was highly critical. As a policy matter, he wants those felons voting. But he didn't, in fact, address the legal issue that as a judge, Judge Barrett was obliged to address. And Section 2 of the 14th Amendment provides in relevant part, but when the right to vote at any election is denied or is in any way abridged, except for participation in rebellion or other crime. Well, Senator Durbin may not like that the 14th Amendment explicitly contemplates that if you commit a crime, if you're a felon, you may forfeit your right to vote, but that is in the text of the Constitution. And as a judge, Judge Barrett would be not doing her job were she not to look at the text of the Constitution and follow the text of the Constitution. Am I right, Judge Barrett, that the Second Amendment doesn't have similar language suggesting or other crime or anything comparable to that?
You are correct.
All right, a third point. There's been some discussion from Democratic members raising the question of the Federalist Society and dark money and all sorts of mysterious connections. Now, Judge Barrett, am I right that at least for a period of time you were a member of the Federalist Society? Is that right?
While I was on the faculty as a full-time tenured professor.
And you've spoken at some Federalist Society events. Is that accurate as well?
I have.
In your time dealing with the Federalist Society, have they ever lobbied you to take a particular position?
They have not.
In your time as a judge, has the Federalist Society ever filed a brief in your court urging an outcome in a particular case?
It's my understanding the Federalist Society doesn't litigate. They have not ever filed a brief in my court.
Your understanding is correct. The Federalist Society does not file amicus briefs. Our Democratic colleagues have been engaged in a sustained effort to try to sully the Federalist Society. It is disconnected from reality, but I will say, and I wish Senator Whitehouse were here. My intention was to have this discussion with him here because he just spoke about all the connections. He had his charts. I would note, I was feeling a little bit bad that I didn't have a chart with sort of red fuzzy yarn connecting all the things that are the deep conspiracies going on. So in that interest, I do have a chart that's a little bit smaller that has similar connections back and forth, and it is produced by, the Americans for Public Trust, and it shows the dark money connections between Senator Whitehouse and Planned Parenthood and Arabella Advisors and all of these different organizations with money flowing back and forth, all the dark money. And in fact, I would note one of those dark money organizations on the left that we talked about yesterday that is the Demand Justice Organization. I would point out the Demand Justice Organization has decided to be directly involved in these proceedings because this is a left-wing dark money organization that has posters that are right outside of this building that have pictures. Senator Lee, you're on the poster. Chairman Graham, you're on the poster. And the posters say, Supreme Super Spreaders, politics first, health and safety last. You know what? The First Amendment's a great thing. If they want to put your pictures up, it's a pretty good picture of Senator Lee. It's not as good a picture of Chairman Graham. Needs to work on getting a better picture to them.
It's not their fault.
The Democratic dark money efforts dwarf the Republican dark money efforts, which is why, without a twinge of hypocrisy, Democratic members make this charge repeatedly. And in fact, I will point to one specific example, which is a Judge John J. Jack McConnell, who is a judge in the state of Rhode Island. Now, who is Judge McConnell? Well, he used to be the treasurer of the Rhode Island Democratic Party and a director of the Rhode Island branch of Planned Parenthood. Well, how did Mr. McConnell become a judge? Well, according to CQ roll call, he contributed about $500,000 to Democratic political committees before becoming a judge. This, by the way, is more than any other judge nominated by Obama or Trump. So Judge McConnell stands at the top, $500,000. He donated $12,600 to Senator Whitehouse. He hosted a fundraiser for Senator Whitehouse at his home in Providence in 2006. Judge McConnell's wife gave another $250,000 to candidates and causes, so that's $750,000. And now Judge McConnell is a judge after Senator Whitehouse vigorously led the fight to get him appointed a judge. He sits on the Committee on Code of Conduct of the U.S. Judicial Conference. And what has he done on the Committee on Code of Conduct? He has helped lead the charge to issue a new rule to try to ban judges from being members of the Federalist Society. And to the shock of no one looking at the red yarn connections, after Judge McConnell and the committee put out this assault on the Federalist Society to prohibit judges from being members, Senator Whitehouse and 6 other Democratic senators loudly cheered that effort in writing. Now, fortunately, that effort was roundly denounced. Over 200 federal judges signed a letter opposing this. Federalist Society takes no positions, doesn't lobby, doesn't file amicus briefs, doesn't take public policy positions. Most of its events are debates where people on the left are featured prominently. Every single U.S. Supreme Court justice, all of them, have spoken at least one Federalist Society event. And thankfully, the assault on the Federalist Society was withdrawn in the face of over 200 federal judges, and I would note 29 senators roundly criticizing the attempt. Let's turn to a fourth issue. Many Democratic members of this committee seem to be treating this hearing as a policy hearing on what's good healthcare policy, what's good gun policy, what's good voting rights policy. Judge Barrett, in your view, is it the responsibility of a federal judge to implement policy positions that they might happen to agree with?
That's your job, not a judge's.
I very much agree with you. It's easy for someone watching these proceedings to assume both sides want the same thing, just on opposite partisan lines. It's easy for someone watching to assume, well, the Democrats, they want Democrat judges implement their policy, and the Republicans, they want Republican judges to implement their policy. As easy as that is to assume, I don't believe that is accurate. It is certainly not accurate with respect to the sorts of judges I would like to see nominated and confirmed. And I'll give you an example of that. An issue that I am deeply passionate about is school choice. I think school choice is the civil rights issue of the next century. But I also think the right arena to fight for school choice is right here in the United States Senate. The right arena to fight for school choice is in the state legislatures. It is in the politically accountable elected legislatures. So, do I want to see a federal court issue an order mandating school choice across the country? It might be simpler if I could just convince 5 justices to order every jurisdiction in America, you must have school choice. It would be a lot easier than trying to convince 51 or 60 senators, trying to convince the House. We've gotten school choice legislation passed through this body that I've introduced, but it's been hard fought. It'd be much easier if 5 philosopher kings could just mandate it. But that would not be an appropriate judicial role. And I'm certainly not asking Judge Barrett to issue any ruling, although I believe that policy is the right policy. It's not a judge's role to mandate it. Interestingly enough, our Democratic colleagues do support judges prohibiting it. If you look at a case called Zellman versus Simmons-Harris, that was a case that was a challenge to Ohio's school choice program. Ohio's school choice program gave scholarships to thousands of low-income children, mostly African-American and Hispanic children, trapped in failing schools. It gave them hope. It gave them a chance at a decent education, a chance to escape violence, a chance to have a shot at the American dream. It was immediately challenged. The case went to the Supreme Court, and by a vote of 5-4, the Supreme Court upheld the program. 4 justices were prepared to strike down that program as unconstitutional, and with it, every other school choice program in America. To rule that the Constitution doesn't let the elected legislatures decide to give scholarships to kids if they choose to go to a religious institution. As far as I'm concerned, that's a radical and activist position. 4 justices were ready to shut down school choice programs all across the country. That's an example of how one side wants the court to mandate their policy outcomes. The other side does not. I don't want school choice mandated. I want it to be left to the political process. For my last couple of minutes, I want to address one other issue, which is the issue of packing the court. We have seen repeatedly Joe Biden and Kamala Harris refuse to answer whether they would pack the court. What does it mean to pack the court? Packing the court means one very specific thing, which is expanding the number of justices to achieve a political outcome. Packing the court is wrong. It is an abuse of power. I believe, should they win in November, that our Democratic colleagues will pack the court. I think that's why Joe Biden refuses to answer it, although he did say when asked, the voters don't deserve to know his answer as to whether he'll pack the court. And what we've seen this past week is we've seen, with a message discipline that is really quite remarkable, Democratic senators all making a new argument that what Republicans have done for 4 years is packing the court. With all due respect, what utter nonsense. Filling judicial vacancies is not what that term means, and they are endeavoring to redefine the language, to set the framework, to set the predicate for a partisan assault on the court. I will read you some quotes. Joe Biden in 1983, quote, FDR's court packing idea was, quote, a boneheaded idea. It was a terrible, terrible mistake to make. And it put in question an entire decade, the independence of the most significant body in this country. Pat Leahy in 2017, quote, the Judiciary Committee once stood against a court packing scheme that would have eroded judicial independence. That was a proud moment. Senator Blumenthal, much the same. Senator Durbin in 2018, quote, 75 years ago we went through this, and I think the Congress was correct in stopping this popular president named Franklin Roosevelt from that idea. Justice Ginsburg in 2019, quote, if anything would make the court look partisan, it would be that. One side saying we're in power, we're going to enlarge the number of justices, not fill vacancies, enlarge the number of judges, so we would have more people who would vote the way we want to. 9 seems to be a good number. It has been that way for a long time. I think it was a bad idea when President Franklin Roosevelt tried to pack the court. That's the next fight we're facing. If Democrats win the majority, I hope that we don't see that come to pass.
Thank you. Senator Cruz, we'll come back at 12:30 and we'll lead off with Senator Coons. 12:30. hearing will come back to order. Senator Klobuchar.
Thank you very much, Mr. Chairman. Hello, Judge.
Hi, Senator.
Hello. I want to start out again by reminding friends at home, people at home, that this isn't normal. We shouldn't be here right now. We are in the middle of the pandemic and people are sick. We are in the middle of the election and people are voting. And yet here we are stuck in a nomination hearing. I know what my constituents care about, what they've been calling and writing me about. And that is they are afraid of losing their health care in the middle of the pandemic. People's lives depend on the Affordable Care Act, like Steve, a senior from Tower, Minnesota, who has a heart condition and relies on his prescription medication. Emily from Minneapolis, mom was diagnosed with breast cancer. Janet from Rochester, whose brother has a mental illness. Or Christy, a mom from Bloomington, whose daughter had a tumor. That is what is on the line. Healthcare is on the line. And Judge, that's what's on the line in your nomination hearing, which unfortunately has been plopped in the middle of this election. This morning you had, I would call it an academic discussion with Chairman Graham about the doctrine of severability. And that's about if you can uphold part of a statute but throw out another part of it. And you correctly said there is a presumption to save the statute if possible. So I want to be really clear with the American people that the Trump administration's own brief, this is the position of the Trump administration, filed by the Trump Justice Department, says that the entire Affordable Care Act must fall. That is the position of the Trump administration going into this case that's going before the Supreme Court in a few weeks. Judge, you clerked at the Supreme Court. Does the Justice Department's brief that they have filed represent the administration's and therefore the president's position before the Supreme Court?
The Solicitor General is the government's advocate before the court.
Right.
Yes, that would represent the United States.
Right. And if the brief didn't represent the president's position, he would have the Solicitor General and the Justice Department withdraw the brief. Is that right?
I believe so, yes.
Okay. I just wanted to make that clear to the chairman and to everyone out there that while there is this doctrine to separate stuff and to try to uphold part of the statute, like maybe pre-existing conditions or doing something about keeping your kids on the insurance, the position of the Trump administration is to throw the whole thing out. The second thing I want to make clear is that you have been nominated to the highest court in the land, and you will be the deciding vote in many cases that will affect people's lives. And I appreciated that you've said it's not the law of Amy, it's not your law, but the point is that you will be in a really important position. I think that's one of the reasons that they're trying to ram through this process right now. And while you're not saying how you're going to rule on cases, as I said yesterday, I've been following the tracks. And the only way for the American people to figure out how you might rule is to follow your record and to follow the tracks. And we know this. You've said you consider Justice Scalia one of the most conservative judges in our nation's history as a mentor. You've criticized the decision written by Justice Roberts upholding the Affordable Care Act. In a 2015 NPR interview, you praised the dissent by Justice Scalia in another Affordable Care Act case, saying the dissent had the better of the legal argument. You signed your name to a public statement featured in an ad that called for an end to what the ad called the barbaric legacy of Roe v. Wade, which ran on the anniversary of the 1973 Supreme Court decision. You wrote your own dissent disagreeing with longstanding court rulings on gun safety, expressing your legal opinion that some felons should get guns. And you once discussed a dissent in the marriage equality case, asking whether it was really the Supreme Court's job to make that decision. So to me, these tracks lead us to one place, and that is that you will have the polar opposite judicial philosophy of Justice Ginsburg. And to me, that would change the balance of this court, which is already 5-4 and known as very conservative when you look back through history, to 6-3. 6-3. And that would have great repercussions for the American people. So I wanted to follow up on something that Senator Harris and I asked you about yesterday, and that is the issue of whether or not you understood the president's clear position on the Affordable Care Act before you wrote the article in which you criticized the legal reasoning for upholding the Affordable Care Act. The president tweeted just one day after you were nominated, that would be September 27th, that it would be a big win if the Supreme Court strikes down the health law. But before you were nominated, and this is what we showed yesterday, Donald Trump tweeted promising that his judicial appointments will do the right thing on Obamacare, unlike Justice Roberts. Yesterday, you were asked by Senator Harris, prior to your nomination, were you aware of President Trump's statements committing to nominate judges who will strike down the Affordable Care Act? You said, I can't really definitively give you a yes or no answer. What I would like to say is I don't recall hearing about or seeing such statements. And after she followed up, you said that the tweet wasn't something that I heard or saw directly by reading it myself. Okay, so I just want to go through some of the things that have happened over the last few years regarding the president's, really his obsession to repeal Obamacare. He said, we will repeal and replace disastrous Obamacare when accepting the Republican nomination at the Republican convention in 2016. Did you see that speech?
At the Republican convention
in 2016. I'm not asking if you were there. I was asking if you saw it on TV.
No, I don't believe I watched any of the convention on TV. Or
Okay.
I did. I don't remember any of it.
He has said things like, it begins, he wants to immediately repeal and replace the disaster known as Obamacare. He has said that he wants to get rid of it. He has said in States of the Union, I am calling on Congress to repeal it. He said, can you believe that Mitch McConnell, who has screamed repeal and replace for 7 years, couldn't get it done? So there have literally been hundreds of statements by him, by my colleagues, and I just find it hard to understand that you were not aware of the president's statements.
I am aware that the president opposes the Affordable Care Act. I'm aware that he has criticized the Affordable Care Act. I took Senator Harris's question yesterday to be referring to the specific tweet, maybe the one that you have behind you, about how he wanted to put a justice on the court to replace Obamacare. Mm-hmm. And I'm definitely aware of that tweet now. And as I said to Senator Harris yesterday, it came up in some of my calls with Democratic senators, brought it up. But I honestly can't remember whether I knew about it before I was nominated or not. I'm not sure.
But did you have then a general understanding that one of the president's campaign promises was to repeal the Affordable Care Act when you were nominated?
As I said before, I'm aware that the president opposes the Affordable Care Act.
Well, I know you're aware now, but were you aware back then?
Well,
when you were nominated?
Well, Senator Klobuchar, I think that the Republicans have kind of made that clear. It's just been part of the public discourse.
Okay, but then is the answer yes, then, that you were aware
Senator
of it?
Klobuchar, all these questions, you're suggesting that I have animus or that I cut a deal with the president, and I was very clear yesterday that that isn't what happened.
Were you generally aware of the president's statements when you wrote in an article in the University of Minnesota Law School Journal in 2017, the same year that you became a Seventh Circuit judge, that he pushed the Affordable Care Act beyond its plausible meaning to save the statue, that Justice Roberts had done that? Were you aware of that, of the president's statements when you wrote that article?
So that article, Senator Harris told me yesterday, was published in January of 2017. Okay. And a law review article takes several months to go into production. So I can't remember specifically when the conference was. That article came out of a conference for Randy Barnett's book. I can't remember when it was, but I suspect it was before the election. It's not like I wrote it in January of 2017.
But President Trump has been saying this in 2015, in 2016, and that's 2 years. It didn't take you that long to write the article. So my question is simply, were you aware of President Trump's opposition to the Affordable Care Act during that time?
Senator Klobuchar, I have no idea, and I suspect that if the article was published in January, that I wrote it sometime before the presidential election. And again, I want to stress, I have no animus to or agenda for the Affordable Care Act. So to the extent you're suggesting this was like an open letter to President Trump, it was not.
Okay. In the 2017 University of Minnesota Law School Journal that we just discussed, one of the things you said is there is a risk that a faction can run away with the legislative process, but there is also a risk that a faction will conscript courts into helping them win battles they have already lost fair and square. That's something you wrote in that article?
I did. I was responding to an argument made by Randy Barnett in his book, Our Lost Constitution. No, I don't know if it was Our Lost Constitution or not, but yes.
So, I mean, that is what I'm afraid has happened here. They have tried 70 times, the Republicans in Congress, to overturn Obamacare. And now they are bringing this case to the court, and you are going to be sitting on the court. And I find it very hard to believe that you didn't understand that when you wrote the article. So I want to, there's one other piece of this, and that is the effect on the economy. And we all know this has been very difficult. My colleagues know this. According to one Yelp study, more than 800 businesses have closed every day. 30 million people were out of work at the height of the pandemic. We're still down 10 million jobs. And so one of the things that's been going on here is we've seen more and more consolidation, and leading me to antitrust. And that part of this, I think, is the COVID relief package we have to pass, but also antitrust. Competition is a driving force of our economy. Justice Ginsburg, at her nomination hearing, described the Sherman Act as a broad charter. She said that free enterprise is the spirit of the antitrust laws, and the courts construe statutes in accord with the essential meaning that Congress had for passing them. Do you agree with her statement?
The Sherman Act is broadly worded, insofar as it prevents contracts, combinations, and conspiracies in restraint of trade. And because that language is broad, courts have developed a robust doctrine of common law to enforce and bring about its promise of eliminating contracts, conspiracies, and combinations that restrain trade.
Yes, and I think you and I have discussed this before, but in recent years, Supreme Court opinions, by the way, all decided over Justice Ginsburg's dissent, have made enforcing our antitrust laws even more difficult. As a textualist, how would you reconcile the broad language of the Sherman Act with recent judicial precedent that has substantially narrowed the application of the statute in practice?
Let's see, I can say as a textualist how I would approach the Sherman Act. And in the case of the Sherman Act, you're right that it's broad language. The text of the Sherman Act, as the court has determined over time, essentially permits the court to develop a common law. So I think, I haven't really had occasion to decide very many antitrust cases on the Seventh Circuit, but it's an area, because it's largely been left to judicial development, that is controlled by precedent for the most part.
Mm-hmm. It is, and that's my concern right now, is that it has been so narrowed in its interpretation of the Sherman Act, the Clayton Act, that it's almost become impossible for people to bring those cases in any big way. I want to turn to something we talked about yesterday, which is elections. You worked on the recount in Florida that was related to the Bush v. Gore case, including on an absentee ballot issue on behalf of the Republican side of that case. Is that right?
I did work on Bush v. Gore. I did work on behalf of the Republican side. To be totally honest, I can't remember exactly what piece of the case it was. There were no
Don't worry,
challenges.
I'm not going to ask you that.
Okay.
We're in the middle of a global pandemic that is forcing voters to choose between their health and their vote. Are absentee ballots, or better known as mail-in ballots, an essential way to vote for millions of Americans right now?
That's a matter of policy on which I can't express a view.
Okay. To me, that just feels like a fundamental part of our democracy. But, okay, let's try this. Have you ever voted by mail?
I can't recall a time that I voted by mail. It may be in college that I did when I was living away from home, but I I can't, as I'm sitting here, specifically recall a time I voted by mail.
Do you have friends or family that have voted by mail or are voting by mail?
I have had friends or family vote by mail.
And you understand we're operating in a moment where the president is undermining vote by mail, even though a number of Republican governors and Republican senators are supportive of it. Many argue that Bush v. Gore, and back to your earlier work, hurt the court's legitimacy. If you are confirmed, the Supreme Court will have not one, not two, but 3 justices, you, Justice Kavanaugh, and Chief Justice Roberts, who worked on behalf of the Republican Party in matters related to the Bush v. Gore case. Do you think that that's a coincidence?
Senator Klobuchar, if you're asking me whether I was nominated for this seat because I worked on Bush versus Gore for a very brief period of time as a young associate, that doesn't make sense to me.
I just think it's such a coincidence to me. I actually didn't know it until yesterday. But will having justices